You've followed the rules, paid your fees and contributed to this country. The final goals on that journey? Indefinite leave to remain, or ILR, and for many, the ultimate prize, a British passport. But what if I told you that in 2025, the goalposts are shifting? What if the path you thought you were on is changing with new, unexpected hurdles? And what if, even after you've reached the pinnacle and become a British citizen, that status isn't as permanent as you believe? It's a shocking thought, but it's the reality we need to talk about today. The UK's immigration landscape is undergoing some of its most significant changes in years, and for some, this means the dream of ILR and British citizenship might be slipping away. Worse yet, some who already hold that precious blue passport could find themselves at risk of losing it. Please welcome to our in-depth look at no more ILR and British citizenship for these people in 2025, and the chilling reality of losing your British citizenship. Yes, it can happen. Stay with me, because the information in this video is crucial for anyone on a UK visa, applying for settlement, or who is already a naturalised citizen. Let's start with indefinite leave to remain, or ILR. For years, the magic number has been 5. Most people on work routes like the skilled worker visa or on family visas knew that after 5 years of continuous residence, they could apply for permanent settlement. It was a clear, predictable timeline. However, a government white paper published in May 2025 has laid out plans for a radical shake-up. The proposal? To increase the standard qualifying period for ILR from 5 years to a staggering 10 years for most visa holders. Let that sink in. A decade. That means double the time living with the restrictions of a visa, double the time needing a sponsor for many, and double the time before you can truly call the UK your permanent home. This change is intended to make settlement a more earned privilege, based on a longer-term contribution to the UK's economy and society. So, who is affected? The proposal suggests this new 10-year default will apply to most work-based migration routes. There are some crucial exceptions. The government has indicated that partners of British citizens on family visas will likely continue to qualify for settlement after 5 years, as will victims of domestic abuse. People with rights under the EU settlement scheme are also protected by the 5-year rule under the UK-EU withdrawal agreement. But for many others, the path just got a lot longer. And it's not just about waiting. A longer qualifying period means more time for things to go wrong, and the reasons for ILR refusal remain as strict as ever. What trips people up? It's often the same pitfalls. Excessive absences. You can't have spent more than 180 days outside the UK in any 12-month period during your qualifying years. With a 10-year route, that's a long time to keep track of every single trip. Tax discrepancies. The Home Office and HMRC share data. Any inconsistencies between the income declared on your visa applications and your tax records can be seen as deception and lead to a refusal. Application errors. A simple mistake on a form, missing a document, or using the wrong form can result in a flat-out refusal. Criminality. Any criminal conviction, even seemingly minor ones, must be declared. Depending on the sentence, it can lead to an automatic refusal or require a long period to have passed before you can be considered. Immigration history. Overstaying a previous visa or any breach of immigration rules, even if it was years ago, can come back to haunt your application. So, the message is clear. The journey to ILR is set to become a marathon, not a sprint, and every step of that 10-year journey will be under scrutiny. Now, let's talk about the final step. British citizenship. For those who secure ILR, citizenship is the culmination of their journey. But here too, a major change in 2025 is set to block the path for a significant group of people. The key lies in the good character requirement. This has always been a part of the application, looking at things like your criminal record and financial soundness. But on February 10th, 2025, the Home Office updated its guidance with a rule that is both controversial and far-reaching. The new guidance states that anyone who applies for citizenship from that date who has ever entered the UK illegally will normally be refused. This includes arriving without the required entry clearance or making what the Home Office defines as a dangerous journey, such as crossing the channel in a small boat or being concealed in a vehicle. What's truly seismic about this change is that it removes the previous 10-year rule. Before this, an illegal entry that occurred more than 10 years ago would often be disregarded. Now, it doesn't matter how long ago it happened. It could be 15, 20 years. It doesn't matter if you have since been granted refugee status, built a life, raised a family, and been a model resident. The very method of your arrival decades earlier could now be used to deny you citizenship. This will disproportionately affect refugees and asylum seekers, many of whom had no choice but to use irregular routes to find safety in the UK. Critics argue this new rule effectively creates a two-tier system and penalises people for circumstances often beyond their control, potentially violating international conventions on refugees. So if your history includes an entry that the Home Office deems illegal, your path to a British passport, as of 2025, has become incredibly difficult, if not impossible. This is the part of the video that might be the most shocking. You've done it. You've navigated the visa system. You've passed the life in the UK test. You've pledged your allegiance. You hold a British passport. You are a British citizen. Surely that can't be taken away? Wrong. It can, and you need to know how. The power to strip someone of their citizenship is formally known as deprivation, and it's enshrined in Section 40 of the British Nationality Act 1981. It happens for two primary reasons. First, fraud, false representation or concealment of a material fact. This is the most common reason. If it's discovered that you lied or hid crucial information during your citizenship or even any previous immigration application, your citizenship can be revoked. This could be anything from using a false identity, hiding a criminal record, or not disclosing information that would have led to your application being refused. The key is that the deception must have influenced the decision to grant you citizenship. Second, conducive to the public good. This is a much broader and more serious category. The Home Secretary can revoke your citizenship if they believe it is in the public interest to do so. This is typically used in cases involving national security. Examples include terrorism, including encouraging or assisting others, espionage or working for a hostile state, serious and organized crime, war crimes or other forms of unacceptable behavior. Now, a critical question arises: can the UK government make you stateless, leave you with no citizenship at all? Under both British and international law, the government generally cannot deprive you of your only citizenship. However, the Nationality and Borders Act 2022 created more aggressive powers. For naturalised citizens, meaning you weren't born British, the government can now proceed with deprivation, even if it makes you stateless, provided your actions have been seriously prejudicial to the UK's vital interests. Furthermore, the Act also introduced the power for the Home Office to revoke citizenship without giving you prior notice in certain situations, for example, if it's deemed necessary for national security, or to prevent you from preempting the order. And a new bill for 2025 proposes that even if you win an appeal against the decision, your citizenship might not be restored immediately if the government decides to challenge that appeal. In 2010 and 2023, over 1,000 people were stripped of their citizenship for these reasons. It is not a hypothetical threat, it is a real power that is actively being used. The landscape of UK immigration is clearly getting tougher. The path to settlement is potentially becoming twice as long for many, and the criteria for who is of good character for citizenship have been narrowed significantly. The very permanence of citizenship itself has been shown to be conditional. So, what can you do? First, be meticulous. Every application you submit, every piece of information you provide must be flawless. Double-check your dates, your documents, and your declarations. In this new environment, there is no room for error. Second, be honest. The good character test places immense value on transparency. Attempting to deceive the Home Office is one of the surest ways to not only get refused, but to potentially face a ban and have any future status revoked. Third, understand your history. In light of the new rules, be aware of how every part of your immigration journey, including your initial entry to the UK, could be assessed years down the line. Fourth, seek professional advice. The rules are complex and constantly changing. Navigating them alone is a huge gamble. Getting expert legal advice is not a luxury, it's an essential investment in your future. The dream of a life in the UK is still alive, but the journey requires more diligence, more patience, and more awareness than ever before. Don't get caught out by these new rules. Stay informed, be prepared, and protect your future. Thank you for watching. If you found this information valuable, please like, subscribe, and share it with others who need to hear it. And please share your thoughts and questions in the comments below. Let's navigate these changes together.